If you are looking for climate change litigation, you have found it. And if you're looking for an interesting conversation between Mrs. Gale Norton and Professor Gabriel Eckstein, you have also found it. So we appreciate you guys coming today. Sorry, I beat myself to the howdy. Here you go. Just some real quick announcements, because I know you guys didn't kind of care to hear me talk. I just want to let you know we will have 2 open positions for the spring. So if you want to get involved with the Federalist Society, now is your time. We will have an open 1L position. I know I mentioned it last meeting. And then our vice president has got a great opportunity in DC, so he is going to take up on that. So we will have that open spot as well. That means that we will have to have a meeting at some point this semester, so there's not a lot of time left. It may happen during midweek. I'm sorry. We'll send out a doodle poll. On that note, make sure that you have signed up for your national membership. It's $5, people, $5. So sign up for your national membership. If you're not on the national membership roll, you can't be on the board. And then make sure you sign up on the sign-up sheet so you'll get the doodle poll and the information about that. And then we have to do a big shout out to our co-sponsors. We've got the Energy Law Association in the house, so thank you guys for co-sponsoring today. We've got the 2019 Energy Law Symposium coming up February 21st and 22nd. It's our heavy hitter for the Energy Law Association. So we would like input on career panels, who you'd like to see, what you'd like to see. Reach out to Dr. Felix Mormon on that issue. And if you want to be a symposium fellow, just shoot him an email, 4 to 5 sentences about why you want to be involved in that. And I can tell you this much, I did the airport runs last year, and that's a good time to be able to sit and talk with some of the speakers that are coming in. You get one-on-one time with these folks that you wouldn't normally get. It gives you an opportunity to make a connection. And then also, of course, our co-sponsors. We couldn't do an event like this without having our co-sponsors. The Natural Resources Systems Program, which of course provided to us Professor Eckstein for the panel today. So thank you so much to our co-sponsors. Just a little bit of housekeeping. This is how it's going to go down today. We'll have Ms. Norton speak for about 25 minutes, giving commentary. Professor Eckstein will have an opportunity to follow up, about 15 minutes, follow-up commentary. And then we want to leave you guys 15 minutes for questions and answers. And I know I say this every time, and I really probably don't have to, but just keep in mind, no one here on this panel will ever shy away from a tough question. That's what we're here for, to discuss, debate, and decide. But also keep in mind that Aggie attorneys show Aggie hospitality. So when Ms. Norton goes back to Denver, Colorado, we want her going back saying, man, those Aggies were awesome. And the cool stuff is hard questions don't have to be hostile. So just make sure when you're asking those tough questions that you're still building relationships with people on the panel. And then, if you guys don't want to hear me talk anymore, we have our esteemed Dean Audier, who came to us in July of 2018. There are super awesome things about him. They're up on the screen. I don't need to repeat them. I'm going to turn it over.
Howdy.
Howdy.
It's a great pleasure to be here. I will say, particularly for this event, as you introduce it, for a number of reasons. I think it was actually literally my first event that I did as a law professor at Emory Law School. Then it was a federal side event in which I had the role of the punching board. I mean the Gabriel Eckstein role in that to attempt to respond to the distinguished visitor. But in that case, and I'm sure Secretary Norton will not do this, the speaker completely changed the topic. So I had my whole prepared remarks. This was about his book. And then he delivered remarks that had nothing to do with his book. And so I was sitting there as the remarks were being delivered, and I was quickly trying to come up with some new ideas. It's a strategy. Come up with some ideas on the fly. I then afterwards, and there was a whiteboard in there, and I remember to this day, I went up, this is before phones, I always would have taken a picture of it. And so I got up to there, and I was in somewhat of a daze. I started delivering some seemingly responsive remarks, which involved lots of charts and graphs and whatever about federalism on the board that I drew and so on and so forth. And then again, still somewhat in a daze, I sat down, and when I sat down at my seat, the speaker got back up to do his rebuttal of sorts, and he said, I have to say, I feel like I agree with everything that Professor Audier said. And I stood up and realized, well, then clearly I failed. This is the Federalist Society. If I had one job, it was to be disagreeable. So anyway, I have to say, the format of the Federalist Society program, but really the commitment of the Federalist Society generally to this kind of discourse and engagement, challenging engagement around these issues, really is incredibly impressive. And I have to say, it sets a high bar for all of us. When you agree, whether you agree in any given case or you disagree, that the model of challenging discourse and challenging our ideas and challenging our assumptions is one that really we should all aspire to in terms of being great lawyers, and one that I think is very much in the Aggie spirit. So it's also a great pleasure, of course, to introduce Gale Norton as our speaker today. She is currently the president of Norton Regulatory Strategies. She has served of late as a senior advisor for Clean Range Ventures and on the boards of the Federalist Society, of course, as well as of the Reagan Alumni Association and the University of Colorado's Renewable and Sustainable Energy Institute. We, of course, know that she served as Secretary of the Interior during a tumultuous period from 2001 to 2006. Prior to that, of course, she was the Attorney General of Colorado, which, as Attorney General jobs go, is also an incredibly interesting and important and challenging task given the complexities that state navigates. She served as General Counsel for Royal Dutch Shell Unconventional Oil, following her service as Secretary of the Interior. She's been in private practice otherwise in various government positions, a National Fellow of the Hoover Institution at Stanford, as well as a Senior Attorney for the Mountain States Legal Foundation. She did her studies at the University of Denver, and again, is probably one of the most important and influential voices and thinkers on the issues that we're going to be talking about today, and so we're so honored and pleased to have her here with us. Please welcome Secretary Gayle.
Thank you very much. And let me first say it's great to hear somebody start by saying howdy. That is something I've said all my life, and now I'm thinking back and I realize why. My father grew up in Texas and went to Texas A&M for a short time as an undergraduate. World War II sort of intervened in that, and he went off into the military, became an aircraft mechanic, and never looked back. So my experience with Texas A&M, but I was very pleased when I received the invitation to speak here. I have long been active with the Federalist Society. In fact, I knew the founders of the Federalist Society back when they were law students. I was a very young lawyer myself and went to a meeting at the University of Chicago, and I remember sitting around the table in the cafeteria talking with this excited group of students. I never dreamed that years and years later, that organization would still be active and it would have become such an influential organization. I think a very important key to its success is that the Federalist Society never tried to say, this is what we think, you have to think this way. It has always been an organization that sponsored and welcomed debate and discussion and examination of issues from all perspectives. So I am very pleased that we are continuing in that tradition today. I would like to talk today about cases that are attempting to address the issue of climate change in a few different ways. I will give you fair warning. Part of my perspective on this is because as Attorney General of Colorado, I was one of the negotiators of the National Tobacco Settlement. The whole stream of tobacco litigation is something that the attorneys involved in bringing the climate lawsuits tend to use as a model for why they are pursuing the litigation on climate and why that is going to be successful in their views of things. So I'll discuss some of the pros and cons of those things and some of the difficulties about why climate issues may not be nearly as amenable to judicial involvement and judicial resolution as the tobacco cases were. But let me say there are three types of recent climate change cases. The first are those that have been filed by local governments, by cities, counties, in one case a state, that are raising issues that are essentially tort-type issues. It's a public nuisance, it is truth in advertising, it's the whole line of things that go along with a tort approach to litigation. And I'll come back to those because those will be my primary focus today. The second type of case is represented by something just filed by the New York Attorney General's office, which is raised by them, that looks at securities law and says that the energy companies are not being truthful with their investors in revealing what the impacts of climate change are going to be, and in showing that they have accurately portrayed climate impacts in their documents. So that's another type, one that I don't think we'll get into very much today. And the third type is represented by a case called Juliana, and that involves, it's called the Children's Lawsuit on Climate, and there are several filed in other states. Essentially, that raises a public trust doctrine and says that, and I know with your experience in water law, you certainly know about public trust doctrine. That essentially tries to raise a constitutional type argument on the right to a healthy environment, the right to sustainable long-term future that is allegedly being interfered with by government policy on climate. I'll begin by describing the lawsuits brought by the municipalities. The city and county of Boulder were plaintiffs in a lawsuit that was filed this year, alleging that the the energy companies Exxon and Suncor were causing damage to Boulder because of climate change impacts. This follows along with some suits that have been filed by the coastal communities, Oakland, San Francisco, San Mateo, New York City, that are saying raise in water level because of global climate change is going to have an impact on the cities. The cities are saying they are going to have to spend money to respond to changes caused by the climate. In the Boulder case, it is more flooding, it is the dryness and the effect on the forests surrounding. It's going to lead to more forest fires. It's going to have more of an impact on tourism because the ski industry might be affected by climate change. So it's a whole variety of different arguments about what the impacts are likely to be. In the coastal communities, they are talking about, again, flooding, the need to perhaps build seawalls at some point, all kinds of different things that are going to be necessary in the future to adapt to climate impacts. Those cases have been filed in state court, and with one notable exception, the defendants have all tended to move those cases to the federal court. And the cases have stayed in the federal court, and then the defendant companies have tried to remove them from federal court because of federal precedent that has thrown out climate litigation. In essence, the federal courts have looked at the difficulty in terms of separation of powers, then wading into the issue of climate change. When we're trying to litigate in an area that has an existing statutory structure, whether it's Endangered Species Act, or NEPA, or clean air and clean water laws, the courts are essentially in a role of enforcing what Congress has decided and what the executive branch has regulated. In the area of climate, we don't have that same kind of a structure. And so the cases are going in not as administrative cases, but in something that looks much more akin to a regular tort sort of lawsuit. I'm very familiar with environmental litigation, and this is somewhat different than the usual environmental litigation. Most of the time it's in the administrative context, with the idea of challenging something where there are existing statutory standards. When I was at the Department of the Interior, everything we did triggered a lawsuit. We were responsible for millions of acres of forest. And when the forest gets too dense because we've suppressed forest fires for so long, the only way to thin that out and restore it to something more natural is either through controlled burns or through going in with chainsaws and just cutting down trees. Whenever we did that, whether it's 100 acres, a tiny fraction, we'd still get sued. And so we came to joke among ourselves that at the Department of the Interior, getting a notice of intent to sue was about as eventful as getting a letter addressed to occupants. So I'm very familiar with that kind of litigation. There is a new angle on these cases that is, to me, very troublesome. And that is the emergence of contingent fee attorneys who are using this as a way of somewhere down the line, recovering attorney's fees. In the tobacco litigation, we had a series of lawsuits that were brought by each of the attorneys general of the states. And there were some that were settled early on, but the bulk of the lawsuits were settled in a later round, which I was involved in settling. In those lawsuits, most of the states, realizing that this was going to be complicated litigation, expensive litigation, not a whole lot of money in the state budget to pay for it, signed on with contingent fee attorneys. And those attorneys were supposed to get up to 25% of the recovery that the states brought in against the tobacco companies. Well, I was a little bit stubborn and leery of that approach to things, even back before the tobacco litigation. So the state of Colorado did it in-house, which meant I spent a whole lot of time on airplanes going to Washington, D.C. and Manhattan trying to settle the litigation that was ultimately filed. Among the attorneys who were involved in that settlement, final settlement negotiations taking place in Manhattan, and just paint a picture, there were about a dozen attorneys for the state side of things and a dozen attorneys for the tobacco side of things. The attorneys for the states were 9 of us who were employed by state governments, mostly attorneys general, but a few top deputies, and 3 private attorneys. 2 of the private attorneys played a very important role. They were very actively involved, very knowledgeable about the litigation. One of the other attorneys, the other private attorney, only spoke up when the issue was attorney's fees. Never said anything. We spent months sitting in the conference room, never saying anything unless it was about attorney's fees. That settlement ultimately had a price tag of hundreds of billions of dollars. It's one that's paid out over time, so it's a little tough to say exactly what the total amount is, but it is in the hundreds of billions. The attorneys who were involved, sitting around that conference table, those of us who were employed by the state, we didn't even get overtime. Those who were employed on the private side brought in billions of dollars for their firms. And I'm not talking collectively nationally. One of the law firms had several $billions in fees that were awarded to that law firm. Now that would be a rational person to say, how do I go out and get those kinds of fees? And so some of the same people who were involved in the tobacco litigation and some others have now signed up cities for 20, 25%, I think 23% is the highest amount that they're looking to recover in climate change damages. When you start looking at how much is New York City going to have to do to mitigate climate issues in the future, start adding all those things up, well, that can come to a pretty hefty sum. And so you have attorneys who are going out and trying to sign up other communities. They're apparently working in Florida to get some of them signed up with a profit motive that's a lot different from the usual environmental litigation motive. You know, I don't blame people for capitalist tendencies. That's something I usually value. But when those contingent attorneys are exercising the power of government for their own self-funding, that's not appropriate. That creates dangers. I saw it in the tobacco litigation because we were trying to recover damages that the states had suffered in the past and were continuing to suffer, but also because we wanted to change the practices of tobacco companies. We wanted to especially get them away from marketing to kids. You know, they used to have Joe Camel as a mascot for the tobacco companies. They would have their cigarette packs in convenience stores out in front of the counter where it was easy for kids to shoplift. They'd get addicted to nicotine. It was a great investment for the tobacco companies. And so there were a number of different things we were trying to change, but every time you negotiate with the tobacco companies about changing those things, there would be a financial trade-off as well. And there were times when there was a tension between the attorneys general wanting to accomplish the public policy goals and the private attorneys wanting to keep ratcheting up the financial side of things. In the context of climate, you have these suits that are based on the idea of damages as opposed to just being based on the usual desire to change the activities. And I think that raises this possibility of a difference in approach than what has been practiced in tobacco or in environmental litigation in the past. There was another few differences between the tobacco suits and the climate lawsuits. In the tobacco suits, we had a product that really didn't have that much social utility. When you look at it, do we really need to have tobacco in the world? No, not really. When you look at oil and gas and coal and other fossil fuels, those have had a tremendous transformative effect on society from the mid-1800s to today. Our lives are hugely different because of energy development. And so we all know there's a very strong support for having oil and gas continue to function. We know that federal policy has very often encouraged oil and gas development. So the nuisance balancing that takes place is a lot different in tobacco versus the oil and gas cases. A derivative of that is the implication of driving up the cost of the product. If these suits were ultimately successful and caused the oil companies to pay over millions upon millions or billions of dollars, that gets passed along to consumers. That has a negative effect on the economy. It has a negative effect on consumers. When you ratchet up the price of cigarettes, that has public health benefits. And so it discourages people from smoking. And so the analysis there was somewhat different. And the final difference is in terms of the number of defendants. In the lawsuits that have been filed, they've done anything from 2 defendants. In Boulder, it's Exxon and Suncor. Another one of the cases started bringing in coal companies and utilities, a whole wide variety of different potential plaintiffs, potential defendants, lots of different energy companies. When you think about this from a litigation management perspective, if you're a judge looking at this, instead of having a handful of major tobacco manufacturers where you can have a reasonable discussion and set policy. You have many, many, many defendants and potential defendants. And the whole idea of trying to achieve an outcome from that is very difficult. A similarity in the cases is the desire of the plaintiffs to uncover documents. In tobacco, we had a big truth in advertising component to the litigation. And we were basically hearing the tobacco companies do advertising that hinted their products were at least more safe than other cigarettes, or that, as some of the old advertisements used to say, well, more doctors smoke our brand than any other. With the climate change litigation, of course, the plaintiffs are going after all the documents that they can find about studies that were done by the defendants that perhaps might say the defendants had a study back in the 1980s saying that climate change might be a result of fossil fuel development. And that becomes a truth in advertising kind of problem because they continue to develop the fossil fuels, they continue to promote fossil fuels, while those companies knew that they had a study that said there were climate change problems. That's a little different context because the global model is so much different than just the health model, the link between smoking and lung cancer that you find in the tobacco context. And so the idea that an individual defendant can be held responsible for global climate impacts requires, first of all, a fairly specific chain of causation that might be fairly attenuated. And it also requires trying to hold a few defendants responsible for impacts that are caused by activities all over the world. And so it's, again, a much different kind of situation. So how did the courts deal with these things? Most of the federal district courts that have had these suits in front of them have dismissed them. They have found that this is not an appropriate type of litigation to be resolved by the courts. There are too many unknowns, too many public policy implications, too many things that really require the courts to be acting as the legislative and executive branch instead of as the judicial branch. And so this is a type of litigation that raises a lot of problems for our structure of government, our structure of decision making. I know a lot of people are very frustrated by the lack of rapid movement on climate change issues. But going into the courts is not going to lead to a result of changing public policy or having courts impose policies that are going to make a dramatic difference. It may have public policy or public attitude differences. It may reveal documents. It may provide a lot of fora for the plaintiffs to raise their allegations and their concerns. But from a purely litigation perspective, these cases are not a good approach for judicial decision making. I'll stop with that. I'll turn things over to you.
Thank you. This is indeed an honor to be sitting here with you and to be discussing this topic, because this is, I think this is an understatement to say that this is a critical topic that you all should be engaged in. Thinking about how do we deal with this issue. The issue of climate change is, in my opinion, and I think the opinion of the vast majority of professionals who have dealt with this issue, the scientists, the researchers, and so on, globally, have said this is one of the primary concerns we have today as a global society. And so this is something that, again, I think that you all should be engaged in, and whichever side of whichever argument you want to take, the reality is this is a topic we have to deal with in some fashion. So let me begin by saying that, well, in June, in one of these lawsuits that was dismissed against 5 major oil companies, I think Shell and Chevron were some of the ones named. This is initiated by the city of San Francisco and Oakland. The judge, William Alsup of the U.S. District Court for the Northern District of California, said that in his ruling that the dangers raised by the complainants are real and worldwide, and both parties, both the plaintiffs, the municipalities, and the defendants, the oil companies, they accepted the science behind global warming. However, he said, the problem deserves a solution on a more vast scale that can be supplied by a district judge or jury on a public nuisance case, which is exactly what I think Ms. Norton, Secretary Norton, has just argued. So my response to this is I fully agree with what Ms. Norton has said in terms of it would be far better addressed at the legislative and the executive branch. But the problem that we have is, what do we do in the absence of any kind of governmental leadership, vision, or action towards such a solution? What do we do when the U.S. government, as well as the vast majority of these energy companies, especially those involved in the hydrocarbon sector, have had mounting evidence about the potentially catastrophic impacts of climate change on people and the environment since the Nixon administration 50 years ago? What do we do when the administration, currently in office right now, is engaged in what I would call a deliberate effort to ignore, discount the challenges of climate change? And I'll give you just a couple of examples. In April of 2017, the U.S. Environmental Protection Agency, think about what that title is supposed to be, Environmental Protection Agency. They replaced, they overhauled the EPA website. And one of the things they did was they replaced the online climate change section with a holding page, which basically said, and still today, I checked it this morning, that the page is being updated and to reflect the agency's new direction under President Donald Trump. And it also said, we want to help you find what you're looking for, and then provides a search engine for the general EPA website. So you can type in climate change and see where else you might find those words on the website, but there is no climate change section anymore. All of the info that had previously been at epa.gov/climate change, which had explained human activity, the impact of human activity on the warming of the planet and harm to Americans' health and to the crucial ecosystems on which all of us depend, it's all has been taken offline. That was in April 2017, and no replacement yet. Today, or I should say more recently, Andrew Wheeler, who's the now acting EPA administrator and former co-lobbyist, recently said that federal regulations are not necessary to drive greenhouse gas reductions, which for me begs the question, if we don't have regulations as a potential cause of actions for violations of regulations, what are we left with in terms of cause of actions for those who are seeking redress for claims related to climate change? November 4th, just a few days ago, our own president questioned scientists. This is an interview, televised interview with Axios on the HBO. He questioned the scientific consensus on climate change, including the national climate assessment that our U.S. government prepared, and suggested that scientists disagree on the causes of climate change. And this despite the overwhelming majority of climate scientists in the US and around the world who have agreed that human activities are the primary cause of climate change. He also suggested that climate change will resolve itself, saying, is there climate change? Yeah. Will it change back? Probably. That's what I think. With no scientific basis, and this despite the many dozens of scientific findings that global temperatures will continue to increase unless greenhouse gas emissions are significantly reduced. Vice President Mike Pence, just a few weeks before that, mid-October, questioned the scientific research showing that climate change is primarily caused by greenhouse gas emissions, telling reporters that its causes are yet to be seen. The causes are yet to be seen. And this despite the fact that the overwhelming majority, again, scientific research globally shows that it's anthropogenic, man-made. We are responsible for the vast majority of greenhouse gases in the atmospheres and as the primary causes of climate change. So again, I ask, what can we do when the administration that we would want to address this issue, the Congress that we would want to address this issue, is not taking that type of action? This requires advocates to take creative and sometimes inconvenient actions to pursue a remedy. It requires advocates to take action that not only targets the so-called bad actors, but also targets the general public and the government in order to develop a deeper understanding of the issues, but also to pursue policy objectives. And this is one of the points I know you suggested, that this is not, litigation should not be used as a means for policy objectives, and I have to disagree. And I'll give you a couple of examples where that's been achieved. One is the tobacco litigation that you mentioned. The policy objectives dealt with national health issues, people's health issues. I don't know if some of you can remember, I think I remember, or at least maybe I remember seeing ads about this, the medicinal value of tobacco. This was still being touted in the 60s. At least the social value, but certainly all these other health benefits that were being promoted. And as, maybe as a marketing ploy, but certainly accepted by the government in its regulation or non-regulation of tobacco. And the tobacco litigation, even though it did pursue tort in a tort fashion, using all sorts of tort approaches, it did pursue policy objectives of trying to convince the public and the government to take an approach towards tobacco, towards smoking, to the point where today we have smoke-free zones because of the now recognized health implications. We have entire buildings, entire communities that are now smoke-free. There's also a very strong tradition of using litigation for policy objectives where you can't immediately obtain those remedies from other arms of the government, the legislative and the executive. And to me, possibly the best example is the work of people like Thurgood Marshall, who mounted a very successful frontal assault on the entrenched system of legal segregation with a series of lawsuits that culminated in a landmark Supreme Court decision of Brown v. Board of Education. That was a series of litigation, very inconvenient at the time, with a social and a political and policy objective that, yes, it was messy, yes, it was inconvenient, yes, it went against the grain of what people believed at the time, but that's an issue of perception. You mentioned social utility, and I absolutely agree that there is a huge social utility to energy resources. However, social utility is a perception. We used to perceive tobacco as positive. We used to perceive separate but equal as something positive. Today we perceive hydrocarbon sources of energy as indispensable for our economy. But I can imagine in 5, 10, 20 years from now, a large percent of the population can look at the social utility of hydrocarbon-derived energy as irresponsible, as unimaginable in light of the harms that we already know about and we continue to document worldwide. You also mentioned the Juliana case, which I think is something that all of you really should look into. This is a case that's brought on behalf of 21 young people, children, youths, and some young people. And they're arguing that the failure of the government is leading to climate change. Now they're taking a somewhat different approach than the regular tort, nuisance, and trespass argument. And they're pursuing constitutional rights. They're arguing right to a clean environment, including substantive due process right to certain climate conditions, and equal protection right to live in the same climate as enjoyed by prior generations. They're also arguing the common law public trust doctrine, which they're arguing is a guarantee to the right to a climate system capable of sustaining life. And I agree, these are this is a very messy way to go through litigation to achieve these policy objectives. But, and I have to just make a comment about the point you raised about the self-dealing, the lawyers who are now, what's the ambulance chasing type of lawyers that are now looking for these kinds of litigation. I completely agree. This is not the way we should be achieving our climate change objectives. But again, I go back to the question, if the government won't do it, the executive won't do it, Congress won't do it, the energy sector certainly aren't doing it, what else do we have? What options do we have? These are viable options, viable legal strategies, absolutely messy. They are not easy to make, and they may not get sustained in court. But I think as a objective for the long-term policy, which I think is a justifiable objective, this is right now the only option available.
Mrs. Norton, do you want to respond before we start the
Yeah,
presentations?
I'll do a little bit of response. Very, very good points that you've raised. As you said, I do disagree with that approach, and it is in part because of the long-term implications of having the courts make these decisions as opposed to the executive branch and the legislative branch. In most of the situations where we've had the courts play a role, it has been issues that at the time seemed very complex, but in comparison to climate change are not as complex. When you're looking at where the solutions are in climate change, you're talking about evolution of technology and new technologies that can take the place of the older, more polluting technologies. You're looking at balancing out the economic development side and the prosperity side versus the environmental impacts. They're the kinds of decisions that really are not well suited to the judicial context. And so, yes, there may be situations where the whole debate is pushed along by having litigation take place. But it's something that we really ought to stop and think about, whether that's the way we want to go about solving these issues or not. I'm on the board of a company in the electric utility industry. And the electric utility industry has moved away from coal-fired power plants. Now, part of that is because of regulatory pressure, But a lot of that is from public attitudes. And so they're much more thinking in terms of renewable energy. Part of that is because technology has changed the cost structure. Renewable energy in the 1970s was extremely expensive and extremely impractical. Today, it is cost effective and it is a practical choice in many situations. And so those kinds of huge changes need to take place, and they're not things that a court can really force to take place. And so I submit there are other ways of trying to go about these things.
All right, questions from the audience? Oh, many, okay. Let's start with the student first, and then we'll get Perez and Rainbow.
You hinted about causation. There's a causation problem with, because the environment as a whole is such a large system compared to trying to portion fault to a few actors. Do you think that pursuing judgments against those actors could actually change the perception in the conversation from a political one to more of a qualitative one, kind of in the realm of kind of the society at large, if that makes sense? Because right now it seems like it's climate change does or doesn't exist versus like, okay, it does exist, what can we do to change it? Like, do you think the judgments would like kind of help change that conversation?
I don't so much see that as the likely result. I think that the effort is to try and make the oil companies look like bad guys. And that's what was successfully done with tobacco. It has a different effect when you're talking about it with energy companies. First of all is, what is the money going to be used for? We certainly struggled with that in tobacco. Lots of money going into state treasuries, it's going for roads, it's going for schools. It's not really going for health as it was originally intended. And so there's that kind of benefit, I mean, that kind of difficulty in terms of having the message be watered down, even if that's what you're looking at from the plaintiff's perspective.
So we have talked about the whole, let me label it, common law litigation regarding climate change, and we have talked about the executive responsibilities of the action. But there is this other bucket that we don't seem to be, or it doesn't seem to be that fashionable now, and I am thinking in the lines of Massachusetts versus EPA. Whether we can use the statutory framework that we have in place, which is inadequate at best, right? It was enacted in the 70s, and in the 70s, the consensus about climate change is not the consensus today, no matter what the president says. But do you see, and this is for both of you, room to exploit or to try to push the executive and the legislature to do something using litigation based on the statutory framework? Be it Cleaner Act, I don't envision how, but via the Endangered Species Act or Clean Water Act, perhaps?
Those certainly are things that would be more of the standard role for the judiciary to play in terms of looking at those kinds of things, in terms of the factual situations that would be and scientific arguments that would come forward as a result of those kinds of cases. Massachusetts versus EPA, that was essentially dealing with whether carbon dioxide is a pollutant or not. That was one that maybe had a uniquely broad impact and was something that the courts could look at, could wrestle with it and make a decision that has significant implications. Some of the others are a lot more difficult. Think about the Endangered Species Act. Yes, a court can say this species is being impacted by changes brought about by the warming climate or by a drier climate or whatever, climate-related changes. And activities are going to have to take place under the Endangered Species Act to address that, but it really is within a narrow context instead of something that is going to bring about broader changes.
So I'm skeptical because, as you said, that those statutes were developed in the 1970s. They've been tweaked over the years, but not in relation to climate change. And even the tailpipe emissions, the carbon dioxide cases, I mean, that's gonna be one component of climate change. I don't know how else you're gonna fit in all the other, either the greenhouse gases or the sources under the Clean Air Act. Under Clean Water Act, I'm struggling to find a way. I think there's a little bit more opportunity under the Endangered Species Act, but it's still a stretch. Those statutes are not designed to deal with climate change, so I'd love to have a statutory approach as opposed to common law, but I don't see one.
Professor Rainbow, your hand.
Thank you for being here, Secretary Norton. I really appreciate it. And it's an honor to have you. I feel from your talk, it's reminding me a little bit of an experience I had with my mother. I grew up in Atlanta, and I went off to college in New York, and I realized that the civil rights movement had gone on all around me, and I really hadn't known it because I lived in suburban Atlanta. And I came home and said to my mother, where were you? What were you doing? Black people were being so mistreated. And she said, well, I just didn't think Dr. King was going about it the right way. What I feel missing from what I heard from you is the sense of urgency. We know that in the next few years, we're going to have irreversible damage from climate change. And I heard Professor Eckstein say, what should we be doing instead of going to the courts? And I really haven't heard an answer. And so I'm just wondering what that option is, other than using the courts the way they're being used, whether it's messy or inconvenient or whatever. What is that option that we should be taking? Because it certainly seems to me that we should feel this is wildly urgent, if not the single biggest issue of our time. What the courts are doing is not going to remotely matter if we don't have courts because we don't have a planet.
I guess to a certain extent, I tend to see some of the judicial activity as a diversion from working together constructively on it. I think that I have seen the energy companies. I used to work with Royal Dutch Shell, and I saw them making a lot of investments in doing work on alternative energies, on developing not fossil fuels, but gasoline from algae, those kinds of things that I think are the types of things that are going to have more benefit in the long run. And so pursuing an approach that says, let's try and get billions of dollars out of the energy companies. Let's make this into a litigation situation instead of one where people are discussing things in terms of public debate. I think it's a different approach that, yes, I understand people wanting to have urgency, but urgency in the wrong direction is not necessarily really moving things ahead.
So your answer is let capitalism do it?
No, capitalism, executive branch, legislative branch, those kinds of things are the appropriate way to do it.
I see another question in the very, very back, and then we'll come to you.
Yeah, that was one of my things too.
Hey, see if we can't hear you.
Oh, sorry. That was one of my things too about like capitalism, right? You talked about like profit motives and things like that, and so I'm wondering if our legislators like change ever so often, right? And so does their ideology, right? And as you pointed out earlier too, like that means that they change the way they view climate change and the environment and things like that. Is how do you guys view the role of like capitalism, like basically like profit-based motives, in actually affecting our climate in like negative or positive ways?
I tend to focus on technology and the development of new technologies. And I worked with a venture capital group that was trying to raise money that would be invested in startups that were doing clean technologies, mostly around renewable energy. And it was very exciting. That was, the kind of thing where you can really see changes taking place. And I've also talked with a number of researchers that are doing work along those lines. If a court comes in and tries to order that something is going to take place, they run into, that we are going to shift away from fossil fuels and to renewable energy. That is a transition that has been the stumbling block for the democratic processes making those kinds of changes. You just can't wave your magic wand and have that kind of change take place. And I think that the capitalist system, people wanting to do as they've done in the computer industry, develop new technologies, get those implemented, profit by making changes in that way, I think that has a lot of very strong possibility that takes place without having a court trying to mandate that.
So I'm a big fan of public-private partnerships, and I think there's great opportunities for the private sector to get involved in innovation, technology, and so on. But you've got to have a public-private partnership, and if the public is not there, if the government is not there, in fact, when the government is actually taking actions that are facilitating the old technologies and clamping down on the potentially new technologies, I have a hard time seeing how this can progress and how the market can actually step in. It becomes a disincentive for the market to be innovative, and that's.
Two more questions. One here, and then we'll finish with our energy law.
Okay, so you both mentioned that this is a very global problem, and I think we're all aware that it very much is. But countries such as like Denmark and Germany have done a very, very good job at implementing clean energy and limiting their emissions. So I guess, like, how do you think America's system of government can kind of mimic what they're doing, and maybe acknowledge there's a problem is the first step, but what do you think they could do to do that?
Well, first of all, we have done a great deal in terms of minimizing our emissions in exactly the way nobody would have expected, which is by the shale gas revolution has caused utilities to switch from coal to natural gas, and so our emissions have made more progress than most of the European countries and countries around the world. And so we've seen, this is an example of technology not mandated by government, making a change that has been beneficial. The European countries do tend to have a different approach on these things, but they have utilized an approach that I like, which, except the way we've tried to implement it has been a disaster when we tried. But I did work back in the 1980s on emissions trading, which is now similar to cap and trade approach. And that's the idea of essentially by establishment of property rights or establishment of a structure that provides a government overview and then allows competition and market forces to be applied in developing new technologies and implementing technologies and so forth. Instead of it being government mandates, it's a government structure that then encourages a beneficial outcome. And I think that has a lot more opportunity to make some real headway. And so there are experiments taking place all over the world with different approaches, and we'll see how those different approaches, how they work.
Sure. First of all, big difference between Europe and the United States is perception. Perception of priorities, of the value of the environment as part of the habitat of people. The majority of Europeans are what we say more green than Americans, and that's a perception of society. It's something that we as a community have to make that decision. We want to go become more environmentally conscious and so on. And that's a social movement. That's also national policy. The other point I just want to raise, I agree that the U.S. has made reductions in emissions of climate change gases. I am skeptical of the claim that look how well we did because we moved to shale gas production and therefore we reduced our emissions, because we didn't do it for the climate change impact. That was not intentional. That became a side benefit, in my opinion, that we pursued shale gas because of the economic value. The energy giants and the small ones, they all saw the potential of becoming for the first time, ever, or becoming an exporter of energy. It's a money-making thing. I don't think the objective was greenhouse gas reductions. So I'm skeptical of that claim.
Oh, and I don't in any way say that the motivation for the shale revolution was
Yep.
the company saying this will benefit the climate. But I do think it's an example that we ought to look at to say the government doesn't always know how to mandate the right outcome or a beneficial outcome.
And then our last question, sorry, we're running out of time.
A quick yes or no question.
Okay,
Oh.
do you yield a yes or no question to Kristen?
Just real quick, on the heels of the recent midterm elections, and I know we all were paying attention to that, seeing some of the top issues that people were prioritizing in terms of their votes, climate change, environment was not one of them. Is there any chance that this topic, environmental climate change, could be depoliticized? If you know we're too far down that road.
Well, I've been dealing with environmental issues for several decades, and I've never seen it depoliticized, so. It would be, but there are many opportunities for cooperative work, and I think we ought to explore those opportunities. They never get the visibility. Good news and cooperation doesn't make headlines. There's a lot of possibility for things taking place that you may not know about, but there are great things going on.
We in the U.S. tend to be very reactionary. So folks down in Houston might be more amenable to depoliticizing climate change. But the rest of the country, until something big hits them, I'm skeptical.
And then our last question is, you can ask your question. Well, I want to introduce you at least. This is the president for the Energy Law Association. So if you guys are interested, and I think you are because you're here, in energy law, certainly see Philip and other members of the Energy Law Association board. But please ask your question. We're here. We're hanging.
So I became an environmental scientist because when I was in the military, I couldn't find ways to get people to do the right thing, right? And we needed incentive to incentivize them. And we've seen the same thing in the history of the United States where companies didn't do the right thing. The Cuyahoga River caught on fire multiple times. Like people have major issues with developmental issues and all because of environmental issues. Because companies weren't willing to do the right thing. It took government involvement. Now this government might not be willing to get involved, but once the government does get to that point, where do you think carbon taxes fit into there? And that just got shut down in Washington State this past election. But if that could, how would you see that implemented?
I guess I'm skeptical of some things like that because of my involvement that I mentioned in emissions trade and my enthusiasm for that idea in general. I saw it work with acid rain provisions in the Clean Air Act that have really had great benefits without a lot of micromanagement by government. But when that same kind of context was brought to Congress to try and implement, it became free money. And every member of Congress had some great idea about how this free money ought to be spent. And what was a beneficial program or had some potentially good elements to it fell of its own weight because it was free money in the political process. I am concerned that carbon tax is even more something in that direction because it is purely economic. And so from the perspective of making some changes in terms of the carbon intensity of economic activity, yes, that's an approach that might be better from an economic perspective, and better from an economics kind of perspective. It still allows people to make free decisions about how to implement it. But again, from a government perspective, I have my concerns about having lots and lots and lots of money go from the private sector into the government.
Professor Eckstein, you have a comment on carbon tax?
I don't disagree. I'm also skeptical about, or not, I should say skeptical, I'm hesitant about carbon taxation because I like the idea and concept because you can tax it at different levels. I'm hesitant about what the government could or couldn't do or wouldn't know what to do. And I do agree that the acid rain example I think might be a much better example in terms of credits and so on, in terms of a way to manage these kinds of emissions.
Well, I certainly thank you guys, especially for coming and staying 10 minutes after. If you have any interest in the Natural Resources Program, Professor Eckstein, Professor Exotic-Rez, Professor Guillermo, all of them can talk to you about the classes that are coming up. And certainly go on the website, click on the link so you can get information. So thanks again, guys.